The process is real. Uh, the process is essentially, I think, important just to make sure what you've accumulated and what you leave behind after you pass away is passed to the people A, you want to receive it, and B, it's passed down in the manner in which you want them to receive it. So that old, adage, you can't control from the grave, is really not true, because if you plan properly, you can kind of control how your heirs receive your assets after you pass away. And so, that first slide really is just the beginning stages, right? When you talk about estate planning, and estate planning is essentially just a fancy term for putting together the documents that say how your assets pass. So every time I mention estate planning, people say, I just want a will. Well, that's essential. That's what estate planning is, right? When you put a will together, that's planning for your estate. Whether it's $100 estate or whether it's $100 million estate, everybody needs a will, and that will controls what happens to your assets. But it's important when you're starting that process, obviously, you want to identify what it is that you want this process to achieve for you, right? Make sure that you gather all of your information, all of your asset information, all of your beneficiary information, and kind of just make sure you outline that to the person, the attorney preparing the documents for you, so that they have a good understanding of what your overall goals are before they start to, prepare any documents for you. They should understand what your goals are with respect to your planning, and what, your overall family situation and financial situation is, so that should all be discussed at that first meeting before any implementation of any documents are put together. And then, like Adam said, it's a good idea, once it's in place, review it from time to time, because situations change. And if you don't adjust your plan because, and something has happened in between the time that you put it together and you pass away, that plan might not reflect your current intentions. So it is important just to review it every so often.
And Tim, from an estate planning standpoint, we're going to get into the documents on the simplified level. We're going to get into the taxation and the different processes. But I thought, starting with the end in mind, and just sharing a story from a personal story of mine that Tim helped me out tremendously with. But then, thinking through, I know many of you that are on this call have experienced a death in your life. We at Forefront, we help, I would say we help two to five families. We don't look forward to doing it, but we help 2 to 5 families a year with estates that need to be settled. And when that estate planning process, what we're going to talk about tonight, I want to just kind of bring you back to when my mother passed away a number of years ago. She, about a week before her death, she didn't have a will, and I was able to get a will. Tim and his office were able to help us draft and execute documents before that process, before my mother finally passed. And I had to go through probate. But thank God I had the documents in place, because it cut down on any family squabbles, any issues, anyone worrying about things that they don't need to worry about. The fact that I had in writing what my mother's final wishes happened to be and how she wanted assets to be passed alleviated the pressure on me to make decisions and allowed me to have the peace to mourn during that period of time. And when we work with our clients here, and Tim, I'd love for you to maybe comment on this as well from your experience with estate administration, because there's a planning part, but why it's so important to plan, because when someone does finally pass away, the family is there that needs to administer everything. And if it's done correctly, the family is at peace and can follow a logical order. But when it's not done, what I have noticed is families not able to, they're not worrying about or going through the mourning process, which is what, and the memory of that person. It ends up becoming potentially a very contentious scenario. So Tim, can you comment on that from an estate planning standpoint?
Yeah, you're absolutely right. I think a well planned out estate does exactly that. One, it cuts down on arguments between family members, which is always important, right? Because when you talk about legacy in the beginning, the last thing you want your legacy to be is a family at turmoil, a family that's fighting, right? And so a well planned out estate is not going to eliminate every fight, but it will, hopefully minimize the disputes, because what you want to have happen is, laid out in your documents. And then second, it does, save on the administrative and legal cost of administering an estate. When you have a well-planned estate, the legal expense and overall administration expense is drastically cut, because there are things that you took care of in advance that your heirs won't have to plan for. So I definitely think that having, a planned out estate is going to save both of those aspects. And even little things, because I deal with heirs all the time, and little things like making sure your heirs know what your funeral arrangements are. It saves them that, I don't want to say aggravation or hassle, but it saves them from having to figure out what it is you might have wanted to have had, what your plans were, what your funeral wishes were, so that if that's planned out in advance, it saves them from having to, take a guess at what your plans were, and it saves them that worry.
And again, I stress this enough because I've lived it, and I've lived it personally, and I've lived it with so many clients, and the documents that were in place. Most people, I think that estate planning is about taxes, and we're going to go to that next. But it's really about the passing of documents, so allowing your family members to have that peace behind when you've left this world. But since estate planning, Tim, are there taxes still in play? And because that was some of the things that when I first got into this business 25 years ago and working with clients, people were like, well, I don't have enough money. I don't need to do estate planning because I don't have that issue. But are there some tax implications when someone passes away anymore?
Yeah, there are. So you want to, fast forward. There is a tax. Oh, there you go. Look at you.
Hey.
All right. So, and this is my fault. This is actually outdated, right? So, we're in a great environment right now, estate tax wise, because a lot of states have gotten rid of their estate taxes. Like here in New Jersey, we got rid of our estate tax in 2020. So it's been gone in New Jersey since January 1 of 2020. So as a New Jersey resident, the only estate tax that we have to worry about is the federal estate tax. And the federal estate tax applies wherever you reside, whatever state you reside in. But right now, it only affects individuals with an estate that exceeds $12,920,000. And that 12.07 is actually a 2022 figure, right? So if you pass away in 2023, you can pass away with an estate of 12,920,000 without having to pay any federal estate tax. And so for a married couple, that's double. So it's nearly $26 million for a married couple before any estate tax is imposed. And then again, on the state level, it depends on the estate, so I think there's only about 19 states that still have an estate tax. Most of the southern jurisdiction states, where Adam is right now, Florida obviously does not have an estate tax. I said New Jersey does not have an estate tax. New York still has an estate tax that taxes estates that exceed over $6.5 million per individual. So it really depends upon the state that you live in. So you want to check the laws in the state or contact an attorney or an accountant in that state to determine what estate tax your state has. But like I said, it's a pretty good environment. When I first started practicing, the federal figure for estate taxes was $600,000, meaning that they taxed everything over a $600,000 threshold at a rate of about 50%. So to have a $12 million, almost $13 million exemption at this point is pretty good. The other thing to keep in mind is that $12,920,000 figure It's indexed for inflation, so we'll see another bump up in that number in 2024, another bump up as of January 1, 2025. But there's a scheduled repeal of that law by 12/31 of 2025, that if the law is not made permanent or replaced with another law, that the credit will be essentially cut in half. So we could see a $13 million or a $14 million exemption cut in half on January 1, 2026. So just something to pay attention to if, again, you're in that that level of assets that would exceed, you know, a $6.5 or $7 million exemption. You just might want to be aware of the reduction in 2025 so that you can do some planning if necessary.
And also I see here, what, you know, you mentioned income tax on this and supplement basis. And then I'm gonna throw another thing that's not on this this slide is probate. And I know they're all different, but I'm making you work tonight. So someone passes away, why do we have to worry about income tax?
So it's a good question, right? Because I get this question a lot. You know, if I give a gift or if my heirs receive a distribution of my assets when I pass away, is it income taxable to you? And the answer generally is no. Gifts and inheritances are not subject to income tax. So if you give somebody a gift while you're alive, they do not have to pay income tax on it. If they receive an inheritance from you, they do not have to pay income tax on that inheritance. The big exception to that rule is tax deferred accounts, right? So any IRAs, 401ks that are left to your heirs at death are still subject to income taxes. So your heirs will have to pay income taxes on any IRA or 401k assets that you leave behind. The other thing to note with respect to income taxes is the step up in basis rule. So that that rule says that when you pass away, all of your assets receive a basis adjustment to whatever that asset value was at the time that you passed away. So if you bought real estate for $100,000 and it's currently worth here in New Jersey $1 million, well, there's a built-in gain there of $900,000. And if you sold it while you're alive, you have to pay capital gains tax on that $900,000. If you hold on to that asset until you pass away, your heirs get a basis adjustment of up to $1 million, so that when they sell it after you pass away, their basis for tax purposes now $1 million, what it was worth when you passed away.
Okay. And what about probate? I know I'm throwing probate out there because another thing that clients have asked is like they're so worried about sometimes they want to get a will done because they think that they want to do that so that they can avoid probate, or that probate, there's a ton of costs with probate. There's this misconception out there about probate. Can you simplify what is probate?
So probate is a process of transferring a decedent's assets to that decedent's heirs, right? So when somebody passes away with, let's say, a bank account in their name, that account is frozen until the probate process is completed, right? And so what probate is essentially that every state and every county has an office that oversees the distribution of the decedent's assets. And so that office really is charged with the responsibility of making sure that those assets are distributed to the rightful heirs. So typically what happens is that when somebody passes away, somebody has to make an application to that local office to be appointed either as the executor or the administrator of the estate. And depending on the jurisdiction that you pass away in, that process can be very simple and inexpensive, or it can be very costly and time consuming, right? So probate varies from state to state as far as what the cost will be and what the time allotted to the probate process will be. So here in New Jersey, I think the probate process is pretty simple, but again, it depends upon the size of your estate, the makeup of your estate, and who your beneficiaries are as to what type of probate will be required when you pass away. So again, when you're identifying your goals in an estate plan and you're talking to your attorney about what your goals are, one of those goals should be to minimize the overall probate expense and probate time, right? So that should be definitely a goal of putting together any estate plan. And hopefully that practitioner can go over with you what your particular probate would involve and what the cost would be, so you know whether or not you have to take steps to avoid that process.
So when you transfer assets and asset titling, so and I know we'll talk, people understand the concept of beneficiaries. They understand the concept, but not always how to name them and where they should be named. But then there's some other ways where there are some things that are held in either in a tenants in common scenario or joint tenants with right or survivor. Will those two areas help with probate?
Yeah, so and it's one of the reasons that when we start the planning process, that we want as much information regarding your assets as possible, right? So not only do we want value information for estate tax purposes, but we want titling information to make sure that we know how those assets will pass when you pass away. So if you own an asset jointly with somebody else, how you own it jointly is going to depend how that asset will pass when you pass away. If you own an asset jointly with rights of survivorship, that asset is going to pass to the surviving joint owner, meaning that your will does not control that asset, right? So if I have a joint bank account with you, Adam, and I, in my will, say all of my assets go to my spouse, the joint bank account that I owned with you will go to you, will not go to my spouse. So the titling of that account overrides what you have in the will, all right? Tenants in common is another form of joint ownership, but it does not have the rights of survivorship. So if you and I own a bank account as tenants in common, 50% of that account will pass to my heirs under my will when I pass away. You retain your 50% ownership in that account, but my 50% will pass according to the terms of my will. So that's why, again, it's important when you're getting all the information out for your estate plan that you identify not only value, but how assets are titled.
So, piggybacking on with joint tenants with right or survivorship, over the last 25 years, I would say majority, we'll use that term because I know you're a lawyer. We don't want to have anything too blocked in, but the majority of my married clients are that they use joint tenants with right or survivor, and that because especially with their bank accounts, CDs, anything that's after tax, things that are not IRAs, even someone's home, they own a joint tenant with right or survivor, so that when if spouse one passes away, the assets that happen to be owned that way just pass to the surviving spouse, and it doesn't even go through the will. Is that correct?
That's correct. And
Okay.
that's the most efficient way for spouses to own assets, I think, right? So jointly with rights of survivorship, because there's no probate with the joint asset, right? So a joint asset automatically passes to the surviving joint owner. And when there's spouses involved, obviously it's a tax-free transfer to the surviving spouse, right? So it is a very effective way for spouses to own assets. You just have to make sure in your plan, when you're identifying goals of how your assets pass, that joint ownership of those assets falls into, and achieves those goals, right? So if, let's say, I was in a second marriage and I wanted half of my assets to pass to my children, right? Owning something with my second wife with rights of survivorship is not going to achieve that objective or that goal, right? So you just have to be careful, when you're identifying your goal of how your assets pass. If the goal is everything goes to the surviving spouse, then, jointly with rights of survivorship is a great way to do that.
Well, in your scenario, if you had a second marriage, and I think I know the answer to this, but you opened this Pandora's box. But would you own a, let's just call it a bank account or an investment account, tenants in common with your second spouse, so that your half can be passed through your estate documents and the other half passes to your spouse?
Yeah, that's the better way to own it. If again, your goal is to make sure that your half of those assets pass to your children and not to the surviving spouse, you would either want to own those in a separate account, or if it's a joint account, that it's a joint tenant in common account.
And I'm just going through a question, and there is a Q&A feature on the bottom of your Zoom account. So if you have any questions, go to the Q&A and just type in questions. And I'm actually watching the Q&A section, but I'm asking a follow-up question for things. In that scenario, if again, second spouse in this scenario, you wanted your half to go to your children, but you passed away and the account was tenants in common. What happens after your death? Is that account now frozen until until there's a probate, so that the other spouse, the other controller of that account, now has no access to that money either?
So the financial institution can release the 50% to that spouse, but the other 50% would be frozen
Got it.
until there is a court-appointed either executor or administrator.
Okay, that's good to know. How about traditionally beneficiary arrangements? What's the most efficient way? And beneficiaries, we talk, I talk about beneficiaries in so many different aspects with IRAs or insurance or annuity policies, benefits through pensions. So what are the different beneficiary designations, and what do people need to be really cognizant of while they're making those choices?
Yeah, so again, similar to having an account joint with rights of survivorship, if you have an account with a beneficial arrangement, whether it's payable on death or a named beneficiary of a life insurance or retirement plan, you just have to be aware that, again, the person you name as the beneficiary will receive those assets. So getting back to my example, if I name you as a payment on death beneficiary of one of my brokerage accounts, and in my will, I say everything goes to my wife, well, that account will not go through my will to my wife. It'll pass pursuant to the terms of the beneficiary I have on file. So again, it's an efficient way to leave assets. There's no probate required for a payment on death beneficiary designation, either through a brokerage account or an IRA. But you just want to make sure, again, when you're identifying your goals, that's where you want those assets to pass, right? You want those assets to pass to a named beneficiary and not through the terms of your will. So many assets pass by payment on death and contract beneficiaries these days. So
yeah, we use that a lot here as we call it, and we have TOD accounts, transfer upon death, which I see there on the bottom, and sometimes we set that up from the standpoint that there is there's liquidity for the family right at death, so they can make sure they can handle final arrangements or anything that needs to be done while probate and waiting for death certificates and things along that nature that have to happen. So there's capital that's available for the family to deal with things.
Yeah, and that's true, but you do have to be careful, right? Because I have had situations in the past where all of the liquid assets had named beneficiaries, right? So they all passed to named beneficiaries, and the only thing that passed through the will was an illiquid piece of real property, right? And now the estate is also the entity that's responsible for payment of all taxes, payment of all expenses, including funeral expenses, right? So as executor of the estate, if I only have an illiquid asset, it may be tough for me to satisfy those immediate expenses because all of the liquid assets have passed to other named beneficiaries, right? I either have to go back to those beneficiaries and ask them to contribute to the estate for payment of those expenses, or I'm going to have to sell that piece of real property pretty quickly to meet those expenses, right? And so the other thing I just had happen within the state here in New Jersey is that all of the assets went to named beneficiaries, but the tax liability was associated with the assets passing under the will. So this was a very large estate where, again, 95% of the liquid assets went to the named beneficiaries, piece of real estate in the passed through the will, and the will said, my will pays all estate taxes. So that piece of property that he passed through the will to that beneficiary bore the brunt of all of the tax liability that was passed via those beneficiary designation arrangements, which again is fine if that's the intention, but the person who received that property essentially got less because they had to pay the tax liability for the assets that passed by beneficiary designation. So again,
and they may have to sell that property or borrow money just to pay that estate tax on that property.
Yeah, no, and that's what we're going through here. Luckily, we're in a good real estate market where we think this will sell pretty quickly, this piece of property, before the tax liability is due. But, in a down real estate market, we might not be so lucky. But it's, again, great way to pass wealth. It's very efficient, very quick. You just want to make sure it lines up with your overall estate plan and your will.
Well, we're talking about beneficiaries, and a question did come in, which I thought was a great question. So as a beneficiary, can a beneficiary also be the executor of a will, or is there a
Yeah.
conflict of interest there?
Nope, they can. So
Okay.
it usually is. Yeah. So there usually is. The executor is typically a beneficiary.
Is there a difference between the executor and the beneficiary? Kind of throwing some questions out of order here.
Yeah. So, executor is just the person who is responsible for distributing the assets to the beneficiary. The fact that an executor is also a beneficiary is not necessarily a conflict of interest, but they are serving two different roles, So I field that question a lot from kids who are upset they weren't chosen as the named executor, of a will. Said my sibling was chosen as executor. Should I be upset? And I just ask them, are you a beneficiary of the will? And they say yes. I'm like, well, then that's all you need to worry about. Just sit back, relax, let your brother do the dirty work and the hard job, and you'll get a check in a couple of months as beneficiary. So.
Well, I'm also looking here. I see, contract beneficiaries. Maybe just go through that in a snippet. Like, what's a contract beneficiary?
Yeah, so we call them contract beneficiaries because when you establish a retirement account or a life insurance contract, right, that is a contract between you and the company, right? That you are establishing that financial arrangement with the company, and they're agreeing to pay certain assets to you while you're alive or to your estate after you pass away, right? So as part of that application to that company, you also direct them how to pass those assets through a beneficiary designation, right? So that's all we mean by contract beneficiaries, is that in that financial arrangement you made with that company, they are contractually obligated to make the payment to the beneficiary you have named in that application.
And then this is an interesting piece, and we have this conversation all the time with clients. Designated beneficiary is basically first, second, third. How does that work? And it, just explain how that works in an IRA or just anything.
Yeah, so in any IRA beneficiary arrangement, they will allow you to not only name a primary beneficiary, but secondary and sometimes tertiary beneficiaries, right? So I think it is important that in that beneficiary arrangement, you decide, here's the person I'd like to receive it if I pass away, and then here are the people I'd like to receive it if my first beneficiary doesn't pass away, so that you know exactly what happens. In your will, we always specify, pass it to these beneficiaries, but if they don't survive me, here's how that beneficiary share will pass to them, right? So your wills always take that into account. So should your beneficiary arrangements, right? So you should make sure that in any beneficiary you have on file, that it not only nominates a primary beneficiary, but a secondary beneficiary, so that you know exactly where those assets will pass or who they will pass to if your primary beneficiary is not alive when you pass away.
And this kind of comes up with a scenario that we've been walking into often with clients recently, is just talking to them about primary, secondary, and tertiary beneficiaries. The assumption that a lot of people have is that, oh well, if their child is the primary beneficiary, they'll get it at the person's death, the decedent's death, and then it'll go to the child, and then after the child passes, then it will go to the secondary beneficiary, and then after that it goes to the tertiary beneficiary. But that's not really how it works, is it?
You're saying that if the primary beneficiary is alive?
Yes.
Yeah, because then they can redesignate their own beneficiary.
Correct. So
Yeah.
right. So whomever gets it, then from there, the secondary and tertiary beneficiary are basically null and void. Now it's up to the control of the primary the person that inherited the money.
Yeah, and again, that's a good identifying your goals. If your goal is to make sure that the assets pass to your primary beneficiary and then to your secondary beneficiaries, right? And making sure that your primary beneficiary can't override the secondary beneficiary's interest, then a trust can be established for that beneficiary's interest, right? So that's when your planning involves creating a trust for those assets so that you dictate what happens while that primary beneficiary is alive, and then what happens to those assets after the primary beneficiary passes away.
We'll get into trust in a couple of slides, but the last one, because I think this is actually an interesting bullet point that we can expand on a little bit. And there's new rules in special consideration for IRA contracts. Basically, if money is passed not to spouses, what happens now?
So same rule for spouses, right? Spouses are still entitled to a rollover into their own IRA and subject to their own minimum distributions at their retirement ages, right? But if you're a non-spouse beneficiary, you can no longer take that account or that IRA over your life expectancy, right? So as a child, if I receive an IRA from my parents, I used to have the ability of taking that over my life expectancy. I just had to take a required minimum distribution based upon my age at the time my parent passed away, and take increasing distributions as I aged. Now the IRS came up with a new rule that there's a 10-year payout period, right? That all IRAs payable to a non-spouse beneficiary have to be completely withdrawn by the 10-year anniversary, December 31st of the 10-year anniversary of my parents' death, right? So what that means is that there's no required minimum distribution during that 10-year period. You can take as much or as little from that account over that 10-year period, as long as by the end of that 10-year period, that account is zero, right? So I can wait until year 10 and take 100% of it out, or I could take it all in year 1, or I could take a little bit out over the 10-year period. So again, no rules as far as how much or when you have to take it out, as long as it's all distributed by that 10-year anniversary mark.
Fantastic. There's a lot to go over on this, and I know what we're going through, and we've already been on for 30 minutes, and there's a lot of things where I am recording this. We'll send out a summary, and we also have the deck that we'll be able to send out to people for review. But let's just kind of get into the basics. So the documents that we're talking about when we're talking about estate planning, what are the basic documents that people really need to go through?
Yeah, so obviously everybody, should have a will, right? So I think you did that poll, 80% of the people on this call have a will, right? And so that obviously having a will avoids the next bullet point, intestacy, dying without a will, right? You die without a will, it complicates the process. There are bonding requirements that are in play, and it just leaves the distribution of your assets to state law rather than as guided by the terms of your will. So everybody should have a will. It names your executor, it outlines who the beneficiaries of your estate are. And if you have minor kids, obviously the will can designate who you would want as a custodial guardian. It's a much easier process when you die with a will than not having a will. Anybody who has assets in their name should have a will dictating where those assets pass when they pass away. Right? And so we already talked about probate considerations, but that should be one of your goals. Like we said, identifying goals in your planning process. Should I be avoiding probate? And if so, how do I avoid probate?
And what you have down there is really the person that you name as an executor is going to be the one, if there's any probate to deal with, he or she will be the one that will deal with the probate process.
Correct.
Got it. And then, so the will is really the document that we're talking about from the estate planning if you pass away. But, since we've just gone through the COVID epidemic and people were worried about different things and health issues, the documents that really have come up lately that I've been trying to stress to clients that is so important to have are the documents while you're still alive. We want to make sure you're protected. So could you go over like what is a power of attorney and how does it work?
Yeah, it's such an important document. I always tell people I think a power of attorney is more important than having a will, right? Because like you said, there's an intestacy process that outlines the distribution of your assets, even though it's a tougher process. But a power of attorney, the only alternative, and a power of attorney is a document that you sign while you're alive that gives somebody else besides you the ability to make your financial decisions should you ever become incapacitated, right? If you ever become incapacitated and you no longer have the ability to manage your own financial affairs, Designating somebody in a power of attorney will allow them to manage those assets for you. If you do not have a power of attorney in effect and you do become incapacitated, the only alternative to a power of attorney is a guardianship proceeding, which is a local court hearing, right, in the county where you reside, that establishes your incapacity and appoints somebody as your guardian, as your legal guardian, right? That process, I'm 6 months into one right now, of appointing somebody as guardian, so that process can take up to 6 months to complete, depending on the situation. But it requires a court to determine your capacity, which requires we get notarized statements from physicians in their opinion stating that you were incapacitated. It requires the appointment of a court-appointed attorney for you, who comes out and visits with you and makes sure that you are unable to make decisions, and they would visit with the proposed guardian to make sure that they are the person who should be making decisions for you. And then ultimately, there's a court hearing where a judge will listen to all of the evidence and decide whether or not you are in fact incapacitated, and then decide who the best person is to manage your affairs, right? So once a guardian is appointed, then the court also makes sure that there is oversight as to their handling of your affairs. So there are annual accounting requirements. There's a bonding requirement, meaning that your guardian has to post a court bond securing your assets while they're serving as your guardian. So it's a very lengthy, costly proceeding that, if you can avoid it just by having the power of attorney in place.
And where should they keep their power of attorney, and how, and do they need the original, like the will, you need the original? What do you need with the power of attorney, and how do you present it to someone?
Yeah, most powers of attorney say a copy is just as effective, but there are financial institutions that require the original. So it is important that you safeguard your original power of attorney. I don't recommend clients distribute their power of attorney to anybody while they're alive, but rather tell your agent that, hey, I have a power of attorney, and if anything ever happens to me, this is where it can be located. So someplace safeguarded that somebody else can access if necessary.
Okay. And then the other document, while we're alive, is very important, and I had to actually use this in my mother's case. So can you walk through what an advance directive is, or like the durable power of attorney sense, and then the living will?
Yeah, I think it's important for two main reasons to have a living will. Is one, it allows you the opportunity to put into writing your feelings with regarding, what we call end of life decisions and medical care that you would or would not want, right? So having the ability to kind of put that into writing, I think, is helpful to the people who are going to be making decisions for you, that you've thought about this in advance and that they're only carrying out your wishes, right? They're not making those decisions. They're just carrying out your wishes. So I think it makes it a little bit easier of a burden for the people making those decisions for you, that you have it written out. The other thing is that without a power of attorney, they generally look, or without a living will, I should say, they generally look to next of kin to make medical decisions up until the point where your decisions or your agent's decisions are not in line with the hospital's, right? So if you don't have a living will, they do not have to listen to you legally as to your decisions for somebody who might not be able to make their own decisions. So again, having this document in place puts your family members in the power seat as far as, over the medical personnel to say what they do and do not want to have happen to their loved one. So it's an important document. Again, powers of attorney and living wills are so easy to prepare and execute. You can probably go online and download the state form for both of them, but just very important documents to have. Easy to execute.
And for this piece, I know, like in hospitals, you walk into a hospital now or talk to clients that they make you fill out a healthcare proxy or a healthcare directive. Do those supersede your document?
Yeah, so if you fill one out, every time you fill one out, it supersedes the one you did before, right? And so hospitals ask you that question now because they've been held liable for making decisions where it's contrary to a living will, right? So they want to make sure that they have the most recent living will or healthcare directive on file so that they don't make any decisions with respect to your medical care that are inconsistent with the living will or healthcare directive you have on file. So that's why they've gotten into the habit of asking for that up front, But
So
you don't need to fill out
if
a
you
new.
have one and you're going into the hospital obviously there's an emergency scenario, but if you're going to a hospital for a procedure, you should have that with you, or someone should have that.
Exactly. I always answer that question, or tell people to answer that question when they ask it. Yes, I have one, and my agent will bring it if the time comes where I'm no longer able to make my decisions, and they'll just mark that in their chart that you do have one and that your agent will bring it if necessary. So again, it's just important that the people you name as your agents have access to it.
We started going down this path before about trusts, and we were talking about this more along the line of beneficiaries and control and setting things up. So what are trusts, and how complicated are they, and how beneficial are they?
Yeah, two main types of trust, right? So revocable and irrevocable. One you can change, one you can't, right? So those are the two main types of trust. And really, when you're identifying your goals with your estate planning attorney, they can tell you exactly what type of trust you need for your planning, right? So revocable trust, really the only benefit of a revocable trust is probate avoidance, right? So if when we're identifying the goals, you identify probate, avoidance as one of your goals, and your estate planning attorney thinks that maybe you're in a jurisdiction where probate, or based upon your assets, probate could be an issue, they will typically recommend a revocable living trust for you, all right? And so what that does is it establishes a trust while you're alive that you control, that you're the beneficiary of while you're alive, that will avoid the probate process after you pass away. So if you create a revocable living trust while you're alive and you transfer all of your assets into it, the title of your home, the title of all bank accounts, the title of all brokerage accounts are inside of this revocable trust, it doesn't affect your ability to change it or access it while you're alive. It simply avoids the probate process after you pass away. That trust is typically established where the beneficiary of the trust is you while you're alive, and then it'll establish your contingent beneficiaries, your family members or heirs after you pass away. Because the assets are in trust and not in your individual name, no probate is required for the distribution of those assets to your heirs, right? So that's the benefit of a revocable trust. The revocable trust doesn't help for taxes. It doesn't help for creditor issues while you're alive. It is simply a probate avoidance vehicle after you pass away. When you pass away, it does become irrevocable, right? So that revocable trust is revocable by you while you're alive. But after you pass away, nobody else can change it. What you have in that trust is set in stone, and the distribution provisions that you have in that trust are irrevocable from that point forward. And irrevocable trust will sometimes use while you're alive just to maybe protect assets from nursing home care or for estate tax purposes. But an irrevocable trust is generally one that you're not a beneficiary of, that you cannot change, alter, amend. So it's for those assets that you're either looking to protect from nursing home costs or from estate taxes if applicable.
I just went back one slide because a question came in, and the question that came in was basically the difference, and maybe we didn't do a great job explaining the difference, or what is the difference between a durable power of attorney and the living will? Is there a difference, and why are there two different things there?
So what they are, so a living will is more of a directive where you are in that document saying, here's how I feel about certain medical procedures, right? If I'm in this situation, I would want that. If I'm in this situation, I would want that. So that's more of your living will advance directive. A durable power of attorney is me saying, I want Adam to make any and all medical decisions for me if I'm unable to make those decisions. So here in New Jersey, we combine them into one form where it's actually the first part of it is me designating an agent. And then the second part is me saying how I would feel about certain medical procedures, right? So I think everybody should have a durable power of attorney for healthcare, meaning they should appoint somebody to make decisions for them. Whether or not you want to go in the advance directive and kind of list out your wishes, I think is helpful to the people making decisions for you to have that in writing again, but their durable power of attorney for healthcare is more important. But that's why New Jersey combined them, because they're kind of equally important, but and they don't want people to get confused and not have one without the other.
Great. And then you were going back to trust. We were going to like the pros and cons of trust. I have had some clients worrying about putting things in a trust because of control issues or giving things away or not having access to things. What are the pros and cons of trusts?
Yeah, so a revocable trust, you don't have that concern, right? A revocable trust, you're not giving anything away. You're still in control. Nothing is given away until after you pass away, right? So the pros of a trust are exactly what is written there: probate avoidance, privacy, and it's tougher to contest, right? So the downside of setting up a trust is really, I guess, the cost to do a trust is more expensive than doing your basic will, right? So that's a downside. As a lawyer, that's a plus, right? Because I'm making more money on the trust than a will. And then retitling of assets is always tough for clients, right? So that you are actually going through the mechanics of having to retitle all of your assets while you're alive, right? So that's definitely a negative to some clients, that it requires more work than just having a basic will, right? When you have a revocable trust, you're actually going through the mechanics of setting up or retitling your assets, right?
So as an example, if all of a sudden if I owned an account in my name and now I wanted to put it into a revocable trust, I would have to go to the financial institution and literally change the account titling into the revocable trust. Now, is the revocable trust, does it have its own tax ID number, or am I still using my own tax ID number? What's going on there?
Yeah, while you're alive, it uses your social. So there's no
Okay.
change in how the account is taxed or how you file your tax returns. You're still filing a 1040. All income on an account in the name of a revocable trust is still reported on your 1040. So that's not a concern at all. If you're in a situation where probate might be a hassle after you pass away, the revocable trust, I think, is just a great tool in the planning process. It's one of these things that I've come to appreciate more the longer I practice, as being a great vehicle for avoiding complication of passing assets after you pass away. So I recommend them probably 9 times out of 10 when I'm doing planning now.
We didn't get into it. I'm not sure if it was on the other slide. We'll go back to that just for a second, and maybe well, we did talk about revocable trusts and then testamentary trust. Testamentary is basically your legal fancy terms for after death is when the trust happens. Okay.
If we made these terms simple, you wouldn't need us to explain them.
But as far as what's not in the deck, just because it comes up so often with clients is, and using a testamentary trust, meaning after someone passes away, what is the scenario of leaving money to children in trust, and are they age terminating trusts or dynasty trusts?
Yeah, so that's definitely in the identifying goals part of the conversation. Do you want your kids to receive those assets at certain ages, or would you prefer a lifetime dynasty trust to control what happens while your children are alive, and then how those assets pass after they pass away, right? So a dynasty trust can accomplish the latter, right? So if you want to make sure that those assets pass to your grandchildren and not to your son or daughter's spouse, then the dynasty trust might make sense for you, because that type of trust controls what happens to the asset when your child passes away. An age terminating trust terminates when your child hits that age. So if you have an age terminating trust that terminates at 30, all of the assets will be distributable to your child at that point. And then if they passed away after the age of 30, their will controls what happens to those assets, right? So that's the big difference between the two of them, is basically control of what happens to those assets after the beneficiary passes away.
A question came in the Q&A. So the revocable trust, which we're talking about here, and this is while you're still alive. So again, going back to me, if I'm alive and I have my assets in my name, it's a revocable trust. So I have an account or a house that's in my revocable trust. It's in my tax ID. It's in my social security number. But in that revocable trust, I've named a trustee. Does that agent have any control over my assets while I'm alive?
No, they do not.
They do not. It's only when the revocable trust becomes a irrevocable trust because I've passed away.
Yeah, so if you are the trustee of that trust, you're in control of that trust. Nobody besides you as trustee are in control of that trust or the assets inside of that trust.
Got it. Okay. Great. And so you know what, let's cover, what is the, so pour over will. So with these trusts, what then is a pour over will with these trusts?
So when we do a revocable trust, we always do what we call a simple pour over will, because again, we're retitling assets into the trust, right? But if we forgot an asset, if there's a bank account that's left out of the trust, what a pour over will does is add that asset to the trust after you pass away. So we're hoping when we're developing this plan that we don't need the pour over will, but every once in a while there's an asset that was left out that we'll need to add after death, and that's all the pour over will does.
In summary, Tim, this has been a lot of information. We'll forward this out. Please, if while we're still on, if you have any other questions, please put them in the Q&A. But what if someone's going to start this process, and what should they be coming to the table with, and how should they be thinking about this? What's the prep for clients coming to the table to meet with their estate planning attorney?
So I have a worksheet that I personally share with my clients before the first meeting that allows them to assemble all of their financial information and all of their personal information, including spousal information, kids information, grandkids information, right? And so having that information at the first meeting is key, right? So what we'll do at that first meeting is we'll go over all that information together, make sure that everything is accurate on there. And then we start the identification of goals conversation, right? So we have all these family members, we have all of these assets. What are your goals for these family members and these assets, right? And then that's when we start to kind of map out a plan of, what, happens with all of these assets when something happens to one spouse, when something happens to both spouses. And then once we map out that plan, then we try to implement it in the form of documents.
And how long does that process usually take?
Most clients, it takes about 4 to 6 weeks to put a complete plan together. Some are quicker, some are longer.
Okay, and we have another question from the Q&A. Going back to the revocable trust, does a revocable trust always avoid probate?
Yeah, as long as the asset's in the name of the revocable trust at death, it will avoid the probate process.
So the key thing here is that if you have a revocable trust, you need to make sure then the assets are titled in the name of the revocable trust.
Correct.
Okay.
And again, there are 3 ways to avoid probate, right? Having a revocable trust and assets titled in the revocable trust. We talked about joint ownership before, right? If you own something jointly with somebody else, that avoids the probate process. And the third way was a beneficiary designation, payment on death designation, right? So those are all ways you could avoid probate with a particular asset.
Fantastic. Right now, so we're 51 minutes into this presentation. Tim looks exhausted. No, Tim, you did a great job as always. Again, if you wanted to talk to Tim, I will make sure that everyone has his email and information and his contact information for estate planning, or you can contact us and we'll put you in contact with Tim to do any review of your documents. Right now, Tim, with how do you meet with clients about estate planning? Is it all via Zoom? Do you do it in person? What's going on?
Yeah, so we'll do both ways, right? So some clients prefer to come in, some clients will prefer the Zoom, and then some clients prefer a phone call. So any one of the 3. If you're local, welcome to come here into the Red Bank office. If you're not local, we can do it over Zoom.
And then, and where are you able to do wills for licensing?
So New Jersey, New York, and Pennsylvania.
Fantastic, great. If you have any other questions, please throw it in the Zoom, or if not, you can always email us after this this seminar, and we will shoot those emails to Tim to get answers. We're going to end tonight. I'm also in the ending of the presentation. We will send you a little survey just to kind of get a feedback of how this went for you. Was it informative? And also a checklist of other events that we'd like to have in the future for you. So again, all have a great night. And Tim Dengler, Thank you very much, Tim, and all your knowledge. Everyone have a great night. Take care.
Thanks, you too.
Bye.